Ladies, gentlemen, judges, afternoon and good morning. My name is Carmen Marie Indalecio. I have a history. My family has a history. My father is Chamorro Caribbean. My mother is French Canadian. Both are proud Americans. I am proud of who I am, and I am proud of the entire range of my cultural heritage. Additionally, I believe in fairness, equality, and justice. Finally, I am very much interested in seeing that the future of this Commonwealth remains bright. March 17th, 1998, Thomas P. Villagomez, Ricardo S. Asquith, Juan P. Tenorio, all CNMI senators introduced for Senate consideration Legislative Initiative 11-1. This initiative proposed a constitutional amendment to amend Article 18, Section 5, to provide that only persons of Northern Marianas Descent might vote on amendments related to matters of land alienation. This initiative passed the Senate on November 13, 1998, and the House 7 months later on June 24, 1999. Initiatives must be ratified by the people, so on November 6th of last year, that hurdle too was overcome. The initiative was ratified by a vote of the people, 6,124 to 4,960. Today, I come here in the hope that I might convince you judges and those here present that the legislative passage of Initiative 11-1 and its subsequent ratification by the people at large is fair, reasonable, and a vital element in the preservation of our local culture. I also seek to demonstrate that Rice versus Cayetano of Hawaii does in no way mitigate the legality or the applicability of the provisions in this initiative. I contend that this new public law is fair, and more, that it is fair to indigenous and non-indigenous citizens of the CNMI. Fair, Webster's unabridged, just, honest, impartial, unprejudiced, with evidence gleaned from the Constitution and the covenant of the CNMI. I shall show that Public Law 11-1 is all of these. June 17th, 1975. 78.8% of eligible CNMI voters approved the covenant with the United States of America. The results of the plebiscite were recorded, and the covenant document was ratified by the United States Legislature and signed by then President Gerald Ford on March 24, 1976. These actions, according to Section 101 of the covenant, place the CNMI, quote, in political union with and under the sovereignty of the United States of America. This was a historical milestone in the evolution of the CNMI. This was a special moment. It is a special document. Contained within that document, that very special document, is Section 805. Section 805 gives the CNMI local government the authority to regulate and limit land acquisition to those of Marianas Descent. Again, this was ratified by the United States Legislature. Again, this was signed by the President of the United States. And it was enacted not to protect one race and disenfranchise another, but to prevent the likelihood of exploitation by foreign interests. And there can be no injustice in that. Now, in September of 1983, after long deliberation and hard work, the CNMI Constitution came into effect. Within it was Article 12. Article 12 implemented the intent of Covenant Section 805 against land alienation. In a letter to the Saipan Tribune entitled Fair Exchange, former associate of the CNMI Supreme Court Justice Ramon Villagomez wrote that the purpose of Article 12 and Covenant Section 805 were and remain to protect the people of the CNMI from the loss of their land. The covenant protects them from being overwhelmed by aliens, by foreigners who come to our shores and subsequently become United States citizens who may consume the land. Now, the CNMI Covenant and the Constitution established that NMI land belonged to the indigenous people. The passage of Public Law 11-1 merely ensured that those who own the land make decisions concerning the land. Logic? Yes. But there are those who disagree. Let us analyze some of their arguments. Let me clarify some of the widely held misconceptions besetting this topic. First, the argument that holds that Public Law 11-1 violates the 14th and 15th Amendments of the United States Constitution is errant. It is errant that unless Congress and the Chief Executive of the United States are powerless to effect treaties or to sign binding covenants, clearly, these are not powerless. In fact, the United States Constitution guarantees their authority, even their responsibility to enact such documents. They passed and signed ours. Now, it is understandable that some may always be found who find any regulations or any restrictions that are culturally or racially motivated to be questionable, even evil. But in the singular case of Public Law 11-1, such thinking is not justified. It was not enacted to restrict the rights of other races, but to preserve a culture, a way of life, and it is duly signed and enabled by the United States Legislature and by their Chief Executive. It is not a matter of money. It is a matter of cultural preservation, and only that. Second, the argument that the indigenous people of the CNMI can buy land and vote on land in the United States, but that stateside Americans cannot buy land, and now by the passage of Public Law 11-1 cannot vote on land issues in the NMI, it is not to be taken seriously. The score is 3.5 million to 176 square miles, that is. Now, we're not even talking the same game. NMI land is the scarcest hope for indigenous culture if local control is lost. And it must not be lost to ill-considered or unrelated precedents, such as Rice versus Cayetano of Hawaii. Which brings me to my third argument. That the passage of Public Law 11-1 is an invitation for what happened with Rice versus Cayetano to happen here in the CNMI. Clearly, ladies and gentlemen, this is not the case. Now, in reality, the basis of the two disputes are unrelated. The composition of the Hawaiian Commission that brought about the United States court case was something that was not previously agreed to by the United States Legislature or their Chief Executive. It was a local ordinance of Hawaii. But the United States Legislature and their Chief Executive did agree to our covenant and to our Constitution. In this difference alone resides strength and unassailability in our special document. Ladies and gentlemen, the case is simple. Public Law 11-1, amending Article 18, Section 5, does no injury to the United States Constitution or to its people. It is not unfair to foreigners who come to our shores and subsequently become United States citizens. It is fair, it is perhaps even generous to the indigenous people of the CNMI. And there is nothing evil about any of that. Now, cultural preservation is an important American principle in this latter age. The passage of Public Law 11-1 ensures that the future of the Commonwealth of the Northern Mariana Islands remains bright, and that the indigenous people of these islands, already outnumbered, may retain the birthright to land held so dear by them. Ladies and gentlemen, I hope that I have been convincing. I hope that I have clarified some of the widely held misconceptions. My name is Carmen Marie Indalecio. I am proud of who I am, and I am proud of the broad spectrum of my cultural heritage. Thank you, Mrs. Sponsor.
Wow. I'll never get tired of listening to that. And that's my daughter, indigenous NMD descendant. No? So I will continue to fight, opposing the abolishing Article 12. And I hope the message was back in 1999 or so, or I think 99. And even back then, my daughter, I think, just covered the whole spectrum of what needs to be explained. So, thank you very much for watching, tuning in, and Guma Husticia.She. And I hope that it allow our new leaders, to really rethink what you're making decision, because the outnumbers of outsiders is still the issue, and it's kind of probably 10 times more than what we were concerned back then in the 1999 or so, So that video that you're watching is on the YouTube, that only 43 have viewed it, and it's sad that, everybody has their own, entertainment, but other than that, I hope that you got something out of that, and thank you very much. Adios and goodbye. Today is Tuesday, March 2nd, and right now it's 10:58. Thank you very much. Adios and God bless everybody. Thank you.